I wanted to talk to you today, give you a brief introduction or idea of how I teach the class by focusing on constitutional law. The constitutional law course is really divided into two sections. In the first half of the course, we talk about the structure of the US government, the separation of powers, and really our federalism, how our system works together. Second half of the course, we focus on individual rights. So individual rights in the form of fundamental rights, things like the right to marriage, the right to weapons, gun control in the United States, which is something that is perhaps a little bit unique, but other interesting issues, I think, with individual rights, anti-discrimination, freedom of speech, and so on. Those topics are perhaps the most interesting, but we start with the separation of powers, and that's what I wanted to talk about today in my introductory lesson, starting towards the beginning of the course with the case or controversy requirement, or what is called standing. And so again, this is a sample of how I would teach a topic in the course. Starting with the background, right, that what you need to know to understand the rules. Our big picture here is that federal courts, we're looking at the power of the courts in the United States, the federal courts anyway, they are only allowed to decide concrete cases or controversies. What that means is they cannot render advisory opinions. If the president or some other politician was wondering if a particular bill might be constitutional, they were worried the court might strike it down, they cannot go to the judiciary and ask for their opinion. Instead, we need the legislation to be passed and enforced against someone so that the court, to tee up a court case so the courts can be involved. The reason for this, the policy concern here, is separation of powers. If the court could provide advisory opinions, it would essentially be advising Congress, telling them what they can and can't do before they do it, and then that would give the courts too much power. So by limiting courts to deciding only cases or controversies, it's a way to limit the power or reach of the courts so that Congress and the president can pass legislation, enact policies without constant supervision. So the court should be on the back end, looking at things after they're implemented, not vetting issues beforehand. Where does this come from? Well, it comes from the text of the Constitution. And in the course, we'll actually spend a fair amount of time at the beginning talking about how constitutional arguments are made. And we'll see that virtually every constitutional argument, or the vast majority of them today, are based in the text of the document. And so if you look at the text of the Constitution, where it spells out judicial power, you can see that judicial power is only over cases or controversies. There is no power in the Constitution to advise or provide advisory opinions. There are actually multiple doctrines or legal rules that you need to know for this concept, but the most important of them, and the one I'm going to talk about today, is standing. With standing, what we're asking is whether we have the proper parties before the court, whether the plaintiff is the right person to be arguing the case, whether they have sued the proper party. That's essentially what we're getting at with standing. As I mentioned, there are other doctrines that look at the timing of the lawsuit and whether the issue might be better addressed by the political branches, but we'll leave those to the full course. So getting to our specific rule for today, that is standing. And for a federal court to hear a case, a plaintiff must have these three things. The plaintiff has the burden to establish these three things: that they have an injury in fact. An injury in fact means that an injury that is concrete and particularized, actual or imminent, and not abstract or conjectural. We have to also have causation, which is to say that the injury must be fairly traceable to the defendant's allegedly illegal conduct. The injury is traceable to what the defendant did. The defendant caused the injury. And then finally, the injury has to be likely to be redressed by the requested relief. What we mean by that is, if the court does what the plaintiff is asking, it will actually fix or at least somehow address the injury that the plaintiff suffered. So again, we have an injury, causation, and redressability. Those are our three elements. And so to establish standing, the plaintiff again has the burden of proof to prove all three. So that's the black letter rule. The next thing we would do is go to the cases. And you can see the black letter rule is not incredibly detailed. We need to go to the cases to understand how the court actually applies it. And one of the most important cases on standing is Luan versus Defenders of Wildlife. And I think it really illustrates the role of standing in the constitutional analysis and the implications if we don't have standing. So in this case, we have a number of plaintiffs, the people who initiate the lawsuit, who sue the government based on an interpretation of environmental regulations. So these plaintiffs are environmental rights groups, and they're arguing that the government is not properly applying the Endangered Species Act. So the Endangered Species Act, important federal legislation, requires all federal agencies to consult with the Secretary of the Interior, with the government, before funding any new project. They need to consult about the effect that project would have on endangered animals. So before the government would build a dam or a new road, a levee, whatever it may be, there needs to be consideration of how that would affect endangered animals. The federal government, though, is only doing this within the United States. It is not considering how funding foreign projects might affect endangered animals overseas. And so the environmental organizations here, our plaintiffs, are suing, saying that the government is getting it wrong, that there should be consideration of the effect on endangered animals, no matter where the project actually is, that it should apply across the globe, not just within the United States. They say that this causes an injury because that lack of consideration for the effect on endangered animals increases their extinction. It harms the populations of endangered animals in the wild. And so our plaintiffs are seeking declaratory judgment and an injunction forcing the government to apply by their interpretation of the statute. Basically, an order from the court telling the executive branch, you need to enforce this across the globe, not just within the United States. So that's our case, and we need to then apply our rule, right? Our rule is that to have standing, you need to have an injury. It needs to be caused by the actions of the defendant, and the court needs to be able to redress that injury. So we're starting with our first element, was there an injury? And the plaintiffs allege several different theories for injury. The court rejects all of them. So injury number one, the first theory from the plaintiffs, is that they are injured when endangered animals become extinct. They are injured because they are environmental organizations and they care deeply about the environment and wildlife. But the court says this is not a particularized injury. For an injury to be particularized, it must treat the plaintiff individually in a concrete way. The plaintiff has to show that they are directly injured rather than just they are offended or they are upset. And the idea here is that if we allowed the plaintiffs to sue based on the fact that they're upset when animals are extinct, then anyone could sue the government for almost anything, right? And that's what we're trying to avoid under the standing doctrine. We don't want the courts to be deciding every issue under the sun that could come up. We want them to instead just be resolving concrete cases or controversies. Just as these environmental organizations are concerned about the animals, you might say, well, people generally are concerned about how their tax money is spent or what their military is doing. That doesn't mean you can file a lawsuit and get the courts to intervene and stop the government from doing what it's doing. You need a concrete and particularized injury. So moving on to argument number two, the plaintiffs say that, well, members of their organizations have visited the areas where these animals live. they intend to return in the future, and that should give them standing because they're going to be injured in a way that is different from the general public. But the court again rejects this argument, saying that is not concrete. It is more abstract and it's speculative. It's speculative because there's no working relationship in these countries. The plaintiffs don't have concrete plans to travel. They just say they might do so someday in the future. The court says that's not good enough. We would need someone that is overseas actually working with the animals for there to be standing, for them to be injured in a direct and particularized way. And finally, they try to argue that, well, some of their members study the animals in captivity, that they work in zoos and they work with, for example, the Bengal tiger, the Asian elephant, whatever it is. And so they're going to have a special interest in the protection of the populations in the wild. Again, the court rejects that argument. They say that, well, if those populations of animals become extinct overseas, how does that affect the animals you have in the zoo? There's no direct connection. They might be upset. They might be more upset than the average person. But again, that's not a direct and concrete injury. You need to be able to tie that somehow to the animals that the plaintiffs are actually working with. So there's no real injury here that is special for our plaintiffs. The court continues to say, even if there was an injury, the third element is also missing. There is no redressability, in large part because the federal government of the United States does not fund all development overseas. In most of these projects, or many of these projects that the plaintiffs are arguing about, US funding is a small percentage of the overall budget of what is being developed in Africa or Asia or Europe or whatever the case may be. And so it's not clear that if the US government changed what it was doing, that it would actually lead to the protection or saving of any actual endangered animals. Okay, so that is at a high level the case. In class, I would try to probably go into it in a little bit more detail. And on the standing issue, we would cover, I think, 3 or 4 cases at least, and then some related doctrines. So in class, we would cover this in more depth. But the next step we would go to would be applying those rules to hypotheticals. And so I have just some quick examples here. They start relatively easy and they get progressively more difficult as we go. So I'll just mention the first one here. It is about someone being upset about how their tax dollars are being spent. Well, just like the environmental organizations have no standing when they're concerned about the animals dying overseas, our individual here, our plaintiff here, doesn't have any strong connection to the way his tax dollars are being spent. There's no special injury to the farmer, just like there's no special injury to the environmental groups. So there would be no standing. In class, I would try to get people to at least type into the chat box their prediction of the answer and try to get a discussion going to draw that answer out. We would then keep going, right? I have several hypotheticals here. I think this is probably the most interesting one, and most of them are based on actual cases. This was a real case that was decided a number of years ago out in California. And the court ends up saying there's no standing, but I'm not going to go into that at the moment. The next thing we would do at the end of the unit anyway, would be to have a practice essay. With the practice essay, of course, we're again learning how to apply the rule. We're working with the law so that we are learning it better, but it also is providing us important practice for writing essays. And so these are the style of questions that would be on the bar exam, and of course that would be on my exam, the multiple choice questions and the essay questions. And when we work through the practice essay questions, I'm not just going to give you the prompt and let you go. Instead, we would work through a model answer. And when we work through the model answer, I would try to coach you on how to best write an essay exam. So I'm not going to go into detail on that just for the purposes of time, but hopefully this gives you an idea of how the course is set up. After this, we would just start over, go to the next issue, give the background, cases, hypotheticals, practice questions. So that's at a high level, the basic structure of the courses in the non-degree program. And for the courses I've developed in the LM program anyway, the approach is similar. It's just that they're asynchronous courses, which means that instead of a Zoom meeting, they are pre-recorded videos that are interactive in that they make you answer the questions, they make you click on the questions, and then there are explanations that will pop up after you go through the hypotheticals.